Hello, my name is Benjamin Hart. I'm an American attorney and the managing director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing the difference between revocation and non-extension of a Thai visa. Now, I got the inspiration to make this video from reading a recent article, but wait for me to sort of cite this and then I'm going to get into the analysis because we're going to go on a slightly, subtly different tangent, and I think it's worth noting for folks that are here in Thailand, especially foreigners. Quoting directly, and I thought of making this video after reading a recent article from the Bangkok Post, bangkokpost.com. Article is titled, Anutin Rules Out Fares Visa Appeal. So, quoting directly, Interior Minister Anutin Chanvirakul said that he would not consider any appeal made by a Swiss man whose visa was revoked for allegedly kicking a doctor in Phuket. Quote, does anyone not want to see his visa revoked? Not this interior minister, unquote, Mr. Anutin said during a visit to Phuket yesterday. And then they go into some analysis about the fact that this person has pending criminal proceedings, from which Mr. Anutin went on, quote, to say, quote, the court case can continue, unquote, he said. It has nothing to do with the visa issue. So again, we're talking about two proceedings when we're talking about court cases versus immigration matters. I've done another video I made contemporaneously with this one where we get into sort of dissecting that. Here's one further data point. It goes even further when you're looking at how this stuff works in practice, is there is also a difference between revocation of a visa and failure to issue a new visa. I'll be very interested to see, in fact, I have a pretty good idea of what this looks like in terms of procedurally. So this person's visa, the accused in this case's visa, was set, I believe, based on prior reporting, I believe by the Bangkok Post, this person's visa was set to expire March 13th anyway. It was going to expire in any event. I believe the current status has now been revoked and this person has been placed basically on a visa, sort of a temporary stay based on any final decision being made in the criminal adjudication. So basically the visa status has been changed. Now I could be wrong on that. He could be just easing out the rest of his visa up until the 13th. But by the fact that they're reporting the visa has been revoked, I'm presuming that visa was revoked and replaced basically with this temporary status pursuant to the conclusion of the criminal adjudication. Both of these are different. So that in and of itself, this person I believe was on a business visa, presumably based on the reporting, that's been revoked. Then now, okay, the person's sitting there on temporary status, again, pending outcome in the criminal case. There's also the issue of, well, what would be the outcome of a favorable adjudication and then maybe I want to get a new visa? Well, you would have to apply for extension. You'd have to make an application to extend, which this person would otherwise have had to have done in the event that their visa expired on the 13th. The reason I'm trying to point out this difference is there is a fundamental difference between revocation of a visa which has already been issued, which, as discussed in another video made contemporaneously with this one, in a revocation proceeding, there may be a right to some form of appeal. I think appeal is too strong a word. It denotes a lot of things, especially in the common law, American common law vernacular, that really isn't present. I would call whatever you want to call appeal maybe expanded review. So one officer can make the decision to revoke a visa, and then you have a period of time to go ahead and ask for expanded review to have that person's decision reviewed, and by like a larger committee, if you will, a commission, strictly speaking, to make the final decision. But again, it's not really an appeal. An appeal kind of presumes an adversarial posture that doesn't exist in an immigration context. The point I'm trying to make is there's revocation, which is basically, if you look at a visa as sort of a license to physically remain in a country, revocation is revocation of that license. But there were certain rights and benefits conferred, and there was certain due process that had occurred to get a visa issued. So you have a form of appeal or expanded review, if you will, in the event that a revocation occurs, because you were detrimentally relying on the fact that you could remain in the kingdom for the period of time stated in the visa, or the visa extension, I should say. Here's the difference. In the case of non-reissuance or non-extension, there is no license granted in the first place. That's the difference. So, they're really, for all practical purposes, I guess you could say, there really is not any sort of appeal associated with just the decision, no, we're not going to re-extend that. We can just exercise our discretion and not allow you to re-extend. In much the same way, an immigration officer, this is the plenary power of immigration at work, really. In much the same way that an immigration officer at a checkpoint in Thailand can state, yeah, I'm not going to let you in. There's no right of appeal or anything. It's just their decision. So again, there's a different sort of legal posture associated with the extension or non-granting of an extension as opposed to revocation of an already issued visa.